So one of the questions asked in regards to the courts was the question, what is the role of the lower federal courts? Now, it's important to remind folks that only the Supreme Court of the United States, or SCOTUS, is specifically mentioned in the U.S. Constitution. And I would ask folks to go back to the U.S. Constitution and look at Article 3, Section 1. So that little squiggly symbol, that's what is commonly referred to as section, the abbreviation for the word section. So I may be using that throughout the time in some of these videos on the courts. But if you go back to Article 3, Section 1, and if you go into your textbook and look for page, let me see if I can find it right quickly here. In the back of the book, page A19. A19 starts Article 3, Section 1. And in it, it talks about the judicial power of the United States shall be vested in one Supreme Court, so there's the Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Notice that it only says inferior courts. These are the lower courts that we're going to be talking about in this video presentation, but it is up to Congress to make the decision as to whether to ordain and establish, and they can do it anytime they want to, from time to time. Look at that key word there, may. We've talked about shall versus may. Congress can create inferior or lower courts to do a couple of key things. First and foremost, to help the caseload of court cases. As the country has grown, as it has expanded, more and more cases are being litigated or tried regarding federal law. Now remember, this is the federal judicial system. Each of the 50 states has its own court system to deal with state law. And sometimes state law can contradict or come into challenge with federal law. That's when it gets brought into the federal court system. But for the most time, in lower courts, lower federal courts, you are dealing exclusively with federal law. Now, this Congress also creates lower courts to have original jurisdiction to actually try a case. If you violate federal law, you have the right to a trial, and that is where original jurisdiction comes from, the original attempt to try a particular case. But Congress has also decided to create lower courts that have appellate jurisdiction, meaning that if you lose at the trial court level, you have the opportunity to appeal that decision and have that trial case process reviewed by a higher court. I'll get into the structure here in just a minute, but this is the appellate jurisdiction that Congress has determined to create and to utilize. So in your chapter 8, there for figure 8.1, which is found, let's see here, I had it before me here, on page 223 of your textbook, figure 8.1 talks about the U.S. court system. And at the top is the Supreme Court of the United States, SCOTUS. But if you work your way from the bottom up, in the federal system, we have U.S. district courts. These are the trial courts. This is where original jurisdiction is oftentimes invested by Congress. If you lose at the U.S. district court level, you can appeal up to the U.S. Court of Appeals. Those courts hear appellate jurisdiction. We'll talk more about the difference again between district courts and courts of appeals in just a minute. If you lose at the Court of Appeals, you can work your way up to requesting a review by the Supreme Court. And in another video, I talk about the role and the process of the Supreme Court, particularly when it comes to the writ of certiorari, or the cert section of the process. Make sure to have watched that particular video for the request for reviews. Now, the U.S. court system includes not just the federal court system, but also state courts. And each state has its own system. There are oftentimes state trial courts, state appellate courts, mirroring what was going on in the U.S. Court of Appeals, and then ultimately within state law and state constitutional issues, a state Supreme Court. But again, if there is what is called a federal question, meaning a state law may infringe upon a federal constitutional right or a federal law, then that decision by the state Supreme Court can be reviewed by the Supreme Court of the United States. So that's kind of the hierarchy, the system that we have for the judiciary. Let's talk about the lower federal courts and begin at the bottom with U.S. district courts. Again, these are the original jurisdiction. And the easiest way to think about original jurisdiction is the notion that this is where the trial begins. U.S. district courts are typically trial courts. And everything that we know about a particular trial, if you've watched Law and Order, this is a perfect example to kind of work our way through using popular culture. You have a plaintiff versus a defendant, perhaps in a civil case. In a criminal case, it's typically the state of or the U.S. government versus whomever is on trial. So you have the two parties, plaintiff and defendant. You have a judge and jury. You hear in original jurisdiction both the facts of the case, but also the application of the law to those facts. And so this is the key aspect when it comes to U.S. district courts that you will not find in the upper level courts. At the lower level, at the trial court level, we hear the facts of the case and we apply the law to those particular facts. Once we do that, the judge and or jury renders a judgment. Now, for the lower federal courts, the U.S. district courts, there are 94 district courts across the country made up of 670 judges that work in those district courts. And a state may have just one district court, one federal district court, or based on population and size, perhaps several that divide up the state. The state of North Carolina has actually 3 federal districts. One for the eastern part of the state, one for the middle section called the Middle District, one for the western section of the state. And again, that's up to Congress to make that decision. These district courts oftentimes hear criminal federal cases or civil federal cases, as well as some administrative federal cases as well, dealing with administrative agencies and people that have issues with a particular bureaucratic agencies. Now, out of U.S. district courts, these judgments can be appealed up to the next level, but there is not an appeal by the government in a criminal case. If the federal government charges you with a federal crime and you are found not guilty, the government cannot appeal that decision up to the next level. Now, the reasons for appeals of judgments at the U.S. District Court may focus on a couple of key areas. Perhaps there was a claim that the trial was conducted unfairly, that there were issues with the process by which the trial was conducted. Perhaps another reason for an appeal was that the trial judge applied the wrong law or could have applied the law incorrectly. This is a source of appeal. Oftentimes, the dissatisfied side may also claim that the law the trial court applied violates either the U.S. Constitution or, if it's in state court, the state constitution. And it's important to remember that states with their state judicial system rely on a state constitution just as much as U.S. federal courts rely on the U.S. Constitution. When you are in federal court and you go from the federal district court, appeals are made to the U.S. Circuit Court of Appeals for that district court's circuit, or what is known as the region. And here's a map of the different courts of appeals, the geographic boundaries of the courts of appeals and the various circuits that are utilized throughout the country. If you'll notice, North Carolina is shaded here with West Virginia, Maryland, along with South Carolina. These 5 states make up what is called the Fourth Circuit Court of Appeals. If you go up here into New England, Maine, New Hampshire, Massachusetts, and Rhode Island constitute the First Circuit Court of Appeals. Go out west to the Ninth Circuit, California along with Nevada, Arizona, Arkansas, Hawaii, Guam, the Northern Mariana Islands, along with Oregon, Washington, Montana, and Idaho. This is probably the largest circuit, not just based on geography, but also based on population. And you'll notice some dotted lines. Here in California, these dotted lines represent the various districts within California. So the Northern District, here that kind of hugs the coast, the Eastern District of California, the Central District, and the Southern District. Now you notice Nevada, Arizona, Idaho, Oregon, Montana, along with the Pacific areas, they don't have any dotted lines. Those entire states are considered one district. Washington is divided into an Eastern and Western district. That's split. Notice that Texas has been divided up. North Carolina is, you can barely see the dotted lines, but here's the dotted line. This is the Western District. Here's the Middle District. And this dotted line that kind of runs along here is the Eastern District of North Carolina. Now for the U.S. Circuit Court of Appeals, this is the appellate jurisdiction court, and they only hear appeals from the district courts in their circuit. So let's go back to the map here one more time. The Fourth Circuit Court of Appeals is based in Richmond, Virginia. So any case that comes out of South Carolina, North Carolina, West Virginia, Maryland, or Virginia goes to Richmond, where the Fourth Circuit is housed. For the 11th Circuit, with Florida, Georgia, and Alabama, the 11th Circuit Court of Appeals is based in downtown Atlanta. And so each circuit or each region will hear appeals only from those district courts in their region. And the key thing that differentiates an appellate court with appellate jurisdiction over the district courts with original jurisdiction is the fact that they will not retry the facts of the case. There are no witnesses, there is no testimony given. It is only dealing with the law, how the law was applied. In this level of courts of appeals, there will be 3 judges that hear the particular appeal. And briefs, otherwise written documents by both sides, will be submitted, and that will lay out the arguments about the law and how the law was particularly applied with the issues of the case. There are also oral arguments made before this 3-judge panel. And the appeals, again, center on the law. Was it applied correctly or not by the district court, by the district court judge, particularly were the procedures followed correctly by the district court in this particular case. Was the law applied correctly? Or could the law have changed due to a particular issue within this case? Now, once this appeal is put forward, the three-judge panels will issue their opinion. And oftentimes, if one side disagrees with the three-judge panel's decision, then you could see an appeal from that three judges to what is called an en banc appeal. That means all of that circuit judges would then hear an appeal from the three-judge panel. Now, it is very rare for en banc cases to be heard by all of the circuit courts of appeals judges, but it could happen. If the opinion and if the decision at the Court of Appeals level is dissatisfactory to one side, then an appeal can be made to the Supreme Court of the United States. I would recommend that you go to the other video about the Supreme Court process to see how that plays out in details. The textbook also does a really good job in terms of laying out the process for appeals work to the U.S. Supreme Court. So again, the question, what is the role of the lower federal courts in American politics? It really is a two-tier system of lower federal courts from the district court and the Court of Appeals. But really, we as legal scholars and those of us who study this particular aspect of American politics look to the lower courts as the workhorses of the federal judiciary. To give you a sense of the caseload, in just 2018, district courts heard a little under 360,000 cases across the country in 2018. The courts of appeals heard a little under 50,000 cases in 2018. To give you a sense as to what the U.S. Supreme Court does as the highest court in the land, typically anywhere from 75 to 100 cases are heard a year. And again, the key things that I would leave with you in terms of the role: district courts hear the original issue or the case. We sometimes refer to them as trial courts, but in the U.S. federal court system, it is the district courts that are the trial courts. And then the Circuit Court of Appeals hear problems, hear issues with the original case. If there is an ultimate appeal, it goes up to the Supreme Court of the United States, but that's for another video that hopefully you've seen.